May it please the Court, in the case of New York State Rifle and Pistol Association Incorporation versus Bruin, myself, Esther Lau, and my co-counsel, Andrew Liang, will be representing the respondents in today's case. Before we begin, I'd like to start off with an introduction of the case at hand. In a series of concealed license applications in the state of New York in September of 2014, the government denied Robert Nash and Brendan Koch permits due to the lack of proper cause. Nash, alarmed by an increase in neighborhood crime, completed a gun training course in the hopes of obtaining a concealed carry license. In a similar vein, Koch wanted to increase his self-defense capabilities and utilize his substantial experience in handling arms. Despite clean criminal records, they were both denied their licenses. With the New York State Rifle and Pistol Association, they both filed a lawsuit in the U.S. District Court for the Northern District of New York against Kevin P. Bruin and Richard McNally, two New York State officials who were involved with the denial of their licenses. After having their case dismissed by the District Court, Nash and Koch appealed the dismissal to the Second Circuit, who summarily affirmed the decision, arguing that the Second Circuit's previous decision in Kolchowski v. County of Westchester was decisive in this case. The Second Circuit's ruling was appealed to the Supreme Court, who granted certiorari on the following question: whether or not restrictions placed on petitioners' concealed carry licenses violate the Second Amendment. The Second Amendment states that, quote, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. In the District of Columbia v. Heller, this court held that the Second Amendment undoubtedly protects the rights of law-abiding responsible citizens to use arms in defense of hearth and home, and that the need for defense of self, family, and property is the most acute within the home. The regulation in question today, codified under New York Penal Law Article 400, lists out the type of licenses that would exempt an individual from criminal penalties based on employment or purposes of license, which includes an unrestricted concealed carry license that allows licensee to carry a firearm concealed. This license is issued at the discretion of a designated licensing officer who can restrict the purpose of a license issued, but the core of the regulation surrounds proper cause, which requires that applicants show a special justification as to why their license should be granted.
New York's licensing scheme is constitutional for three reasons. First, it does not burden the core protection of the Second Amendment's right to bear arms. Second, it serves New York's interest in public safety and crime prevention. And third, New York's licensing scheme is substantially related to its interests in public safety and crime prevention. First, we contend that New York's licensing scheme must be analyzed under intermediate scrutiny, with the reasoning that it implicates abilities outside of what the Second Amendment protects, as the core component of the Second Amendment is self-defense within the home only. Turning to President, the Founding Fathers and several state constitutions noted that the right to keep and bear arms for self-defense had two main purposes. First, it was to defend one's property at home, and second, it was to defend for defense of the state in times of conflict. Because the proper cause requirement under New York's licensing scheme only relates to concealed carry licenses, it does not implicate the core component of the Second Amendment, and thus should only be analyzed under intermediate scrutiny. Second, we argue that on the basis of intermediate scrutiny, New York's licensing scheme survives, as the state has an important, even compelling government interest in crime prevention and ensuring the safety of the public. The licensing scheme is also narrowly tailored to further those interests because the proper cause requirement only applies to applicants who seek an unrestricted concealed carry firearms license, not one within the home. Thus, the proper cause requirement does not burden more protected activity than needed to further the interests. Furthermore, the goal of the proper cause requirement is to mitigate the risk of inevitable misuse of unrestricted concealed carry firearms licenses, even if the targeted use of the license is for self-defense. Because the New York's licensing scheme is narrowly tailored to serve New York's interests in crime prevention and public safety, it is also substantially related to those interests as well, satisfying intermediate scrutiny. Third and finally, the petitioner's arguments that the Penal Code violates the Second Amendment are insufficient because they directly contradict with District of Columbia v. Heller and state court rulings, as courts have long held that regulations against concealed carry firearms were constitutional. In fact, this court also previously held that regulations against concealed carry firearms did not violate the Second Amendment. But even if the regulation is analyzed under strict scrutiny, which requires that a statute be narrowly tailored to serve a compelling government interests, we argue that New York's licensing scheme would survive, because New York's substantial state interests, public safety, and crime prevention still hold and have been found compelling by this court. As previously stated, the statute also passes narrow tailoring because it differentiates between licenses issued to possess handguns within the home and for concealed carry outside the home.
What does the Second Amendment protect?
In the District of Columbia versus Heller, the court declared that the Second Amendment undoubtedly protects the right of law-abiding, responsible citizens to use arms in defense of hearth and home, and that the need for defense of self, family, and property is most acute within the home. Though this establishes the Second Amendment's protection of the right to bear arms for self-defense within the home, it leaves open the issue of whether or not states can enact regulations of concealed carry firearms outside of the home. The majority in Heller argued that the Second Amendment's protections were not absolute and that regulations could be enacted for firearms carried outside the home, even for self-defense. Furthermore, in Robertson v. Baldwin, the court previously even held that the Second Amendment did not preclude restrictions on concealed carry firearms.
Why did the framers include the Second Amendment in the Bill of Rights?
The framers included the Second Amendment in the Bill of Rights because of concerns that a national militia would encroach on the rights of the people to engage in self-defense. Prior to the American Revolution, King George began to disarm the American colonists. When the Intolerable Acts were passed in the 1770s following the Boston Tea Party, he also required the colonists to quarter soldiers within their homes without the colonists' consent. The quartering would be the main basis for enacting the Third Amendment, but it also played a role in the founders' decision to include the Second Amendment. Bearing arms for the defense of one's home and property would certainly be within the scope of the Founding Fathers' purpose for enacting the Second Amendment.
What are the limits of the Second Amendment's protection?
The Second Amendment's protection ends at self-defense that is not within the home. Several circuits have already declared that the core component of the Second Amendment is self-defense within the home only. History and tradition also support such a conclusion, as the Founding Fathers and several state constitutions noted that the right to keep and bear arms for self-defense was notably utilized to defend both defend one's property and home, and also the state in times of conflict. Although the bearing of arms for self-defense within the home may also be supported by history, concealed carry regulations were often enacted by English monarchs and upheld by 19th century state courts.
What weapons does the term arms include?
Samuel Johnson's Dictionary of 1773 defined arms as weapons of offense or armor of defense. Based on the court's previous rulings in Cape Town versus Massachusetts and District of Columbia versus Heller, the term arms includes not only all bearable arms in existence during the writing of the Constitution, but also those that were not in existence at the time of founding. Furthermore, the term is not limited to only weapons that are useful in warfare. In Heller, this court held that handguns were considered arms in a Second Amendment context.
What is the difference, if any, between the verbs keep and bear?
To answer this question, let's turn to the District of Columbia versus Heller, which clearly lays out the definitions of the two verbs keep and bear. Samuel Johnson's dictionary defined keep as to retain, not to lose, and to have in custody, while Webster's dictionary defined it as to hold or to retain in one's power or possession. Thus, Heller holds that the most natural reading of keep arms in the Second Amendment is to have weapons. Next, bear means to carry. Heller upholds the late Justice Ginsburg's definition of bear in Muscarello versus United States, which is being armed and ready for offensive or defensive action in a case of conflict with another person. Importantly, the court affirmed in Heller that bearing arms has no correlation with organized military action.
What is a militia, and why did the framers refer to it in the Second Amendment?
As held in District of Columbia versus Heller, the Second Amendment protects an individual right to possess a firearm unconnected with service in a militia, and to use the arm for traditionally lawful purposes such as self-defense within the home. Heller defined the term militia as all males physically capable of acting in concert for the common defense. In the Federalist Papers, James Madison described a militia amounting to nearly 500,000 of citizens with arms in their hands. The reason why the framers referred to a militia in the Second Amendment traces back to the original intention of the Second Amendment, which was to prevent the creation of a standing militia as well as allow individuals to not only defend one's property and home, but also the state in times of conflict. Additionally, in the Federalist Papers, Alexander Hamilton wrote that a militia would be natural and proper in times of insurrection or invasion to defend the nation against its enemies, violence, faction, or sedition.
How should courts determine if a gun control regulation is considered long-standing?
The determining factor of whether a gun control regulation should be considered long-standing is the regulation's historical roots. Specific to this case, a gun control regulation, it should be considered long-standing if it is deeply rooted in English or colonial jurisprudence. In relation to today's case, in District of Columbia versus Heller, the court ruled that the right to bear arms for self-defense of the home was essential since the colonial age. Thus, the basis of the Second Amendment and its protections are strongly supported by history and are long-standing.
What is strict scrutiny, intermediate scrutiny, and rational basis review?
Strict scrutiny, intermediate scrutiny, and rational basis review are the court's three core methods of testing the constitutionality of law. When no fundamental rights or suspect classifications are at question, rational basis review is utilized and calls for proof that the law in question is rationally related to government interest. In terms of the case at hand today, however, rational basis review has already been rejected for use in analyzing the Second Amendment analysis. In District of Columbia versus Heller, the court ruled against using rational basis, reasoning that if all that was required to overcome the right to keep and bear arms was a rational basis, the Second Amendment would be redundant with the separate constitutional prohibitions on irrational laws and would have no effect. Next, under the standards of strict scrutiny, a statute that implicates a core fundamental right of the Constitution must be narrowly tailored to serve a compelling government interest. However, ruling from almost all of the lower courts point against the use of the strict scrutiny in today's case, as they have ruled that strict scrutiny should only be used regarding the Second Amendment if its core lawful purpose, self-defense within the home, is implicated. Thus, these circuits have held that the possession of concealed carry firearms is not within the core lawful purpose of the Second Amendment, as outlined in Heller. Finally, as evident in Kochalski v. County of Westchester, New York's licensing scheme passes intermediate scrutiny if it is substantially related to the achievement of an important government interest. The petitioners filed a suit because their applications for concealed carry licenses were denied. But in analyzing the facts of the case, it is evident that the state of New York's denial of the petitioners' licenses was in compliance with Article 400 of its Penal Code. Indeed, Article 400 is substantially related to the achievement of an important government interest, as 1 out of 5 violent crimes in the state of New York involved a firearm, and this court has previously ruled that public safety is a compelling government interest.
Is there a difference between openly carrying a firearm and concealed carrying a firearm?
There is definitely a difference between open carrying a firearm and concealed carrying a firearm. The former implicates carrying your gun in a way that is visible to others around you, such as having it strapped to your belt. Concealed carrying, on the other hand, is carrying your gun in a way that is not visible to others, such as keeping it in a bag, your pocket, or tucked underneath a shirt. In most states, the licensing process for openly carrying a firearm versus concealed carrying a firearm is different, as the two are treated differently under the law. This distinction is blurry in the state of New York, as it is a non-permissive open carry state, meaning that open carrying is completely banned, but gun owners are able to apply for concealed carry licenses that are evaluated on a case-to-case basis.
How should the court consider the public safety implications of licenses to carry firearms?
This court should weigh public safety implications heavily and should not discount these implications. Previously, this court already held that both public safety and crime prevention were compelling government interests, and New York's licensing scheme not only furthers these interests, but are also narrowly tailored to support them as well. For one, the legislature made clear to distinguish between licenses to carry firearms within the home and licenses for unrestricted concealed carry outside the home, and one would not request a concealed carry license merely to possess a firearm within the home.
The state of New York has been victim to numerous violent crimes involving firearms. In the last year, nearly 1 out of 5 violent crimes in the state of New York involved a firearm. This high rate means that New York's restriction on concealed carry firearms in public without a license issued on a proper cause is substantially related to mitigating occurrences of firearms-related violent crimes. In addition, the state of New York has seen fluctuating rates of gun violence outside of New York City, and preventing potential misuse of unrestricted concealed carry licenses helps serve New York's interest in crime prevention and guaranteeing the safety of the public.
New York's interests in public safety and crime prevention outweigh petitioners' interests to obtain unrestricted concealed carry licenses for self-defense outside the home. For these reasons, we ask that this court affirm the dismissal of petitioner's case and hold that New York's licensing scheme for unrestricted concealed carry firearms licenses be held as constitutional under the Second Amendment. Thank you.